Good afternoon, sir.
Good afternoon, Chief Justice Allen, Associate Justices. If it please the court, my name is Leo Lawless. I am the pro se appellant. In the decision of the single justice, it was noted in the record that the record did not tend to support the contentions of the appellant, but then went on to state that nonetheless, taking the allegations as admitted, they essentially deferred to the ability of the board that it is permitted to make an independent finding and move to default, take the allegations as admitted to. While the board does have very broad discretionary authority, we're not questioning their authority and their responsibility. The subject of any action of the board also has specific rights and protections under statute. And where it's a license, a livelihood involved, that person does have a fundamental interest and a right to due process in order to be heard and speak on their own behalf. The board does seem to have a tendency to apply those statutes which deny some of these specific rights and protections. In their notice of summary suspension, which was the first contact I had with the board at all, they tend to go to Section 30A, Section 10, which allows an agency to just send out a summary suspension and put the onus for any hearing on the subject to request that hearing. Section 11366B goes directly to the agencies under the health department, and that includes the Board of Pharmacy, Division of Health and Professional Services, professional licensure, rather. In that case, they're required to give a 10-day notice. Here's your summary suspension. There's a meeting or a hearing on this date, this time, at this place. Has to be in the notice of summary suspension. They're also required to have a full hearing on all of the allegations within 60 days of the date of summary suspension. They didn't do that. The fact that they sent me a notice of the date, time, and place of the meeting some 7 to 10 days later doesn't excuse their initial neglect.
Did you withdraw any question about whether the summary suspension was proper?
Pardon me?
Did you withdraw an objection to the summary suspension at some point, or am I?
I had no contact or discussions with the board or anybody until I received the notice on December 23rd. And when I inquired then to the board as to, okay, what is this all about, I was given a litany of, no other way to put it, but basically, I didn't do everything I should have done, and I did everything I shouldn't have done, and then some. The board does have regularly scheduled monthly meetings, which are subject to the open meeting law, Chapter 30A, specifically Sections 18 through 22. Under Section 21(1), which is one of 10 reasons or 10 purposes for going into executive session, and the only one that applies in this case, the intent is to discuss the character, mental health, physical condition, the complaints, dismissal of the complaints, or next steps in the complaints. The subject must be given a written notice of the hearing, must be allowed to attend, must be allowed to speak, and can have the hearings held in open session, not executive session. If I may, you have this in the record, in the briefs. This is just on a large copy. What happens is they're going into executive session under Section 30A, 18 to 21, but they want to apply Section 11366C, which classifies it as an investigatory conference. I have no rights. I can't be there. I can't speak. So you're having They're going into a meeting under a statute which says I can be present.
And
I should be present.
In this respect, you're talking about which meeting? The April 5th, 2012 meeting of the board?
Yes.
Okay.
No, I'm talking about the January and February and April meeting,
Okay,
all three.
all right.
So when they're going into an executive session under the proper statute, but now they want to apply another statute to deny me the rights that I have under the statute for going into the executive session. They also, in none of the discussions held, are they classified as investigatory conferences. They want to now be able to go back and say, well, no, he can't speak then because that was an investigatory conference. Well, you're not calling it that. Even if you can hold two contradictory, even if you can apply two contradictory statutes to the same meeting, you should at least identify which discussion is going to be an investigatory conference and which isn't.
Were these after the adjudicatory hearings that were scheduled for March 26, 27, and 28?
Pardon me?
Were these hearings to which these hearings, were they after the adjudicatory hearings that were scheduled for March 26, 27, and 28?
These are the meetings that lead up to.
These are the ones that lead up to the
Lead up to.
adjudicatory hearings.
It's at these meetings where they actually get into the point and decide, okay, what is the next step? Are we going to move to a consent agreement? Are we going to move to a full hearing? Are we going to dismiss the allegations? These all build up to the adjudicatory session. If we jump forward to this year, 2013, now their executive sessions and their investigatory sessions are entirely separate. They've separated them out. They've broken them out. The only problem here is that although the chairman says they're going into a closed session, which by definition in the statute is executive session, he fails to say why. Section 21B requires you have to announce you're going into session, you have to give a general statement as to what the discussions are that make it an executive session. April 2013. All of a sudden, we're not in closed session anymore, and they're labeled investigatory conferences, and the subject is present. I think it's safe to infer that the subject got notice. It included the meeting. Now, while 11265C does not require the board to give due notice, an investigatory conference is covered by the board's own regulations under 247 CMR 10.04. They must give due notice, it must include the subject matter, and they must give access to the meetings, to the records and exhibits of any meeting. I didn't receive any notice for this meeting, either under Chapter 21, 30A, or under 11265C. I can't speak for any of these other people, but reasonable to assume they didn't.
Well, but I mean, on March 26th, you were present for the first day of hearing.
Yes.
March 27th, you didn't show up.
March 27th, I sent the executive director a document outlining and stating that I would not be present and why.
Okay, and isn't that a default? I mean, they're claiming that you thereby defaulted, and by defaulting,
Pardon me?
that I gather that your sister in a moment will say that's a default, and by defaulting, you thereby admitted to the allegations because you didn't show up for the hearing.
By strict definitions, it is default. But I had reached the point where I honestly felt that I had no other choice but to not participate in the procedure that I felt was unfair, unjust, and violating my rights. When I first went into the board to find out what the issues behind the summary suspension were, and I was given this litany of all these things that I supposedly did and didn't do and everything else, It was put to me, we want you to get a psychiatric evaluation, and we want you to have a substance abuse evaluation. Do you have any issues? No. At that point, I related my past experience, which was positive, with psychiatric help and substance abuse. I wasn't hiding it. But I was not putting it forward as a defense. What came out of the meetings I showed you was a proposed consent agreement which required regularly scheduled psychiatric therapy and random urine screens. That was on February 14th. When I declined that consent agreement, on March 1st, they subpoenaed all my records back to 1987 from hospitals and from my private psychiatrist. Under HIPAA, they have access as a regulatory body. They do have access, but that access should be that minimally necessary. 23 years of records is a bit beyond minimally necessary.
Mr. Lawless, your time is up.
Thank you.
Thank you.
Thank you, Counsel.
Good afternoon, Your Honors. Sue Walker on behalf of the Board of Registration and Pharmacy. I want to address both the reasonableness of the board's sanction order as well as address some of the open meeting issues that have been raised today. But I do just want to respond briefly to your question about the summary suspension hearing. And I think you may be referring, Justice Botsford, to the waiver of the right, his waiver of the right to the summary suspension hearing, which was on page 8 of the administrative record. The Board of Registration and Pharmacy acted well within its discretion when it decided that the protection of the public safety required the revocation of Mr. Lawless's license. There was nothing arbitrary about this decision, and there are no extraordinary circumstances here which would justify this court's interference in that discretion. Mr. Lawless's failure to comply with the board's code of professional conduct and his repeated errors with respect to verifying prescriptions. To name just a few of those errors, he dispensed wrong medication to patients. He doubled the amount of drug a patient had been prescribed. He failed to contact prescribers about the form of the medication that had been prescribed. He verified wrong dosages. He didn't refrigerate medications when it was necessary to do so. These errors were made repeatedly, as is set forth in the order to show cause, and they were not minor mistakes. Second, and very significantly, Mr. Lawless failed to appear at the second day of the adjudicatory hearing. This is very significant because it basically calls into question or demonstrates a degree of disrespect for the authority of the board and the importance of its role as an adjudicator when there's been an allegation of misconduct. This is...
I take it when he defaulted, the person who was presenting the case on behalf of the board finished the presentation, essentially, of the plaintiff's case or the prosecutor's case. Is that right?
Yes, she rested at the end of the second day.
Okay. So the board's decision, and I apologize that I don't have the whole thing in front of me, the board's decision was based solely on his default or on the evidence presented as well?
Okay, so the decision that he had engaged in misconduct was made based on the fact that he had defaulted and all the allegations in the order to show cause were deemed admitted.
Okay.
The board does go on to say that its determination about the appropriate sanction was made on issues beyond the allegations in the order to show cause.
That would mean what? On the evidence presented at the hearing itself?
So it said that it was based on multiple factors and allegations in the order to show cause, his response to the order to show cause, and other information submitted for consideration by the board, including the health-related evaluations that had been obtained, and his disciplinary history with the board and his default. So those were that's an administrative record 97. So in addition to that, the board was confronted with the fact that he had threatened to punch one of his colleagues. Mr. Lawless, in his reply brief, wants to minimize this by saying that it was not a threat that was made directly to the colleague. I think that is of little consequence. It showed, for whatever reason, a real lack of control of his emotional state and a lack of professionalism. And for all of these reasons, the board asks that this court find that there was no arbitrary or capricious decision here and no abuse of discretion. With respect to the further condition that the board placed on the sanction order that any reinstatement be predicated on a demonstration of regular therapy and substance abuse monitoring, this was also perfectly rational because the history with mental health troubles and alcohol dependence. I can address the issue of the default if there are any questions, but I think one of the most important things I'd like to clarify is on the issue of the open meeting. So under Chapter 30A, Section 21A7, the statute allows a public body to meet in a closed session for the reasons set forth in Section 21, which set out all of the executive session allowances, or under the authority of any other general law. And Mr. Lawless objects to two hearings which fall under the scope of General Law, Chapter 112, Section 65C. Those two meetings are the January 2012 and February 2012 meetings. Those meetings, when you look at the minutes that he attached in the addendum to his reply brief, demonstrate pretty clearly that the board was considering the issue of whether or not to enter into a consent agreement. As he said today, as well as in his briefs, he was subsequently on February 14th presented with an offer of entering into a consent agreement. The third meeting that he feels he was unlawfully denied access to is that April 3rd, 2012 meeting. That meeting falls within the scope of Section 18D of the open meeting law. And in that section, the legislature exempted from the meaning of meeting any quasi-judicial board meeting held for the sole purpose of making a decision in the adjudicatory proceeding. And the minutes are crystal clear that on April 3rd, the board was meeting to discuss whether or not to adopt the proposed final decision and order of default that the hearing counsel had presented. So he was not, under the open meeting law, denied access to any ability to present his case to the board or make any statements to the board. And certainly he was provided with an opportunity to do that during the adjudicatory proceeding, which, as you know, he declined to participate in after the second day. So for those reasons, the board requests that this court affirm its decision and find that there was also no violation of any open meeting law requirements.
Thank you, counsel.
Okay, thank you.